Tune in to WebTV Daily to stay up to date and informed on the financial market, personal finance, and more. We have got you covered with all your favorite TV shows, economy and politics, market review, women's series, millennial talk, Islamic Finance Weekly, The Brief, exclusive interviews, events, and we keep you up to date on all the updates in the financial market with the market opening gong. Watch premium content. Watch WebTV. Same news, different perspective.
You've reached the stars. Now let's see you conquer galaxies. You've gone for gold. Let's show you two more treasure chests.
Your story doesn't have to end with you. As a matter of fact, it can continue into the next generation.
The only way to move is up, the way to go.
And the generation after that.
Don't stop.
After all, you've worked hard to get to where you are. Why should your wealth end with you? Let your story continue.
Meristem, let's grow wealth for you.
Ever wondered how you can preserve your legacy? Let's talk about how to set up a simple wills and estate planning. The United Capital Simple Wills and Estate Planning products allow you to state how your assets will be owned, managed, and preserved during and after your lifetime. United Capital Simple Wills and Estate Planning covers living trust, family trusts, wills and executorship, asset disposition, custodial services, and procurement of letters of administration. Here are some of the reasons why our Simple Wills and Estate Planning products is great for you. You can plan your estate using a will or a living trust designed by you. You also take control over your assets and decide the terms and enjoy strict confidentiality, estate protection, and experience estate management. Don't wait another day. Simply download the Invest Now app and complete your KYC to get started.
Good afternoon, good morning, and good evening to all our participants today from wherever you're connecting across the world. My name is Ottoabasi, Abasiekong. I'm the Editorial Operations Manager of WebTV, and I welcome you to the Personal Finance webinar on Wills and Trust, discussing the theme, Planning for the Afterlife. This webinar stems from the 4th edition of the Proshare Personal Finance Report series, which explored estate planning, wills, and trust, and all that individuals need to know to plan ahead for the afterlife. I want to share a very brief story with you. Several years ago, a very prominent Nigerian, very wealthy person, and a politician who has done very well for himself, acquiring assets across the country, received his nephew who came to visit him. And in his palatial home, they were discussing family and life matters. And then his nephew, out of curiosity, asked him, "Uncle, do you have a will prepared?" Obviously, this man is over 70 years, so he was really surprised at the question. And he told his nephew, "I don't have a will. My children know themselves very well, so they should be able to get along in the future when I'm no longer here on earth." That seems to be the perception or views of several Africans who have influential and acquired wealth, and sometimes this disposition to wills and trust has led to the need for more enlightenment on why it's important. The decision and preparation of a will is a necessary and meaningful exercise to ensure the peaceful intergenerational transfer of assets and the guarantee of social harmony within and between families. This webinar will enlighten our participants and the entire public on the essence of wills and trust. So it promises to be a very interesting time for all our participants. But I'd like to share some of the guidelines to all our participants today, because it's very important as you're connecting through the Zoom platform and other platforms that you get to know how you can be really involved in the conversation. For our webinar guidelines, it's very important first to take notes of the following instructions so that for what promises to be a very interesting conversation. The first thing that is very important for you to note is that you need to adjust your volume if you want to make a comment. Sometimes in trying to make out your comment, the volumes may not be adjusted. So take note of adjusting the volume so that if it's too low, you adjust it to a level that you can speak out and hear you. The webinar is being recorded and live streamed on the WebTV YouTube channel, so you can join us through that platform. And to comment and have discussions, use the chat icon. That means you can use the chat icon to make your comments, ask a question, also submit your questions via the Q&A icon, and only this question submitted through the Q&A icon will be answered during the Q&A session. So this promises to be very interesting, like I said. So let me introduce our speakers accordingly. It's my pleasure to acknowledge the following personalities. Mrs. Grace Adejara-Duwon, she's the MD, CEO, Proshare. Also, we have Mr. Teslim Shitta-Bey. He's the managing editor and chief economist of Proshare. We also have Ibidolapo OLUFADE. He's the trust and legal officer for Meristem Trustees Limited. We have Yvonne EZEKIEL. She's the managing partner of Olisa Agbakoba legal firm, and Kolawole OLANIPEKUN is the senior associate and head business development of Stark Legal Solicitors. Just to let you know that we will have our welcome address just to set the pace for this conversation. And we have no other person but the managing editor and chief economist of Proshare, Mr. Teslim Shitta-Bey, to take that session. And I would like to yield the floor to him. Mr. Teslim is a stock market investment analyst, one with very great experience in financial journalism, and of course, the inaugural head of Proshare's content team. He's currently the chief economist of Proshare, and of course, those of you that know Proshare is the foremost financial information hub in the country. So when you see all those reports analysis that come out, we give kudos to the steering leadership of Mr. Teslim Shitta-Bey. Without much ado, I'd like to yield the floor now, Mr. Teslim, and you can take over and give us your very welcome address.
Okay, thank you very much, Otto. It's a pleasure to be here. That's the first thing I'd like to say. With the eminent participants that we have, I'm sure we're going to have a very enjoyable afternoon. Enjoyable not only from the perspective that we'll be educated, but also enjoyable from the perspective that we'll be enlightened. Wills and trusts and things related to estate planning are not particularly exciting topics for people in the area of finance or for society in general. Most people tend to steer away from such topics. There is this African notion that if you talk about death, you're inviting the Grim Reaper, so to say. But in other continents, planning for your death is considered to be essential to living. And that's why I hope those who speak today will convince us that it is necessary for us to acknowledge our mortality, and that there is a necessity for us to plan our mortality. And this is very important when you're looking at a younger generation. I remember some time ago, I talked to the chief executive of a bank, and I asked about the question of planning, estate planning. And the chief executive asked me why I was raising such an issue, that most of the people we were dealing with were below the age of 40 and they're not likely to die anytime soon. And I was really worried because I was saying, why are you going to plan when you're 60, right? I mean, you're already done. I mean, you're halfway done, or perhaps you're 2/3 way done, and you're just planning. So planning is not about tomorrow, it's about today. You don't plan for tomorrow. You plan for tomorrow today. and preferably yesterday you had started planning, right? So this is a very important seminar series, and I'm really excited. Also because I have another anecdote. I used to work for, what will I say now, is a conglomerate that had a financial services business. Now, I had addressed the chairman and asked him the same question. I said, sir, how are you planning to transition to the next generation? That you've done so well, and we acknowledge that, but you need to have an ordered way by which you transfer the assets you've accumulated. And he answered in the very same way that you said in your introduction, that no, he doesn't have a plan. And I suggested, okay, do you have something like a trust that will provide some guidance to how your assets will be used, even while you're alive? And he said, no, he didn't have a trust. And so what he did was to put each of his children in charge of the different companies. At that time, there were 13 companies. As we speak today, I think only 2 of those companies exist. So it goes back to the issue that if he had actually planned properly, perhaps at least more of these 13 companies would be alive, and there'd have been a much more orderly issue of how the assets that exist will be distributed after he leaves the planet. But I'm sure with the excellent people we have, I'm so excited about the quality of people we have who are going to talk today. And I hope that they will not only tell us standard fair knowledge, but give us insights into their own personal experiences with the challenges that go with wills and trusts in Nigeria. Wills and trusts have challenges globally. Whichever continent you're in, you're going to find that there are difficulties in regards to intergenerational transfer of assets. However, what are the unique Nigerian experiences that exist? And in what manner can we navigate around these problems and provide solutions to those who are coming up and want to plan their estates and transfer assets to a new generation? You know, Proshare recently decided to investigate what he called the not-for-sale economy. And what we found out was that there's a tremendous amount of dead assets right across the country. Public sector assets that are lying fallow, as well as private sector assets that are lying fallow. Now, the private sector assets that are lying fallow are linked to the what we call not-for-sale economy. So when you drive around Lagos, for instance, you see several houses that are unoccupied, and you see the sign, this house is not for sale. Or you say, you drive around other states and you see this land is not for sale. And when you investigate a little bit further, you find out that the problem is there has been no deliberate effort at transferring assets to the next generation. So that's why I said that this speaks to the research we're doing in the not-for-sale economy. And I hope that, and I actually know, because of the quality of people who we're going to have talking today, that we'll address this issue squarely and prefer solutions to this problem. In actual fact, one of our in-house friends had advocated for what he called financializing dead assets, bringing dead assets back to life and creating value by making those assets that were hitherto dead come alive, or what you could call the Lazarus effect. So we call them forth from where they're buried and make them begin to earn cash flows that will add value to the economy, because by using those assets, you create employment, employment creates income, and government gets revenue. So everybody wins across the board. So I want to welcome everybody to this occasion, this webinar, and I hope that everybody feels very free and comfortable to participate in the webinar. And even though it seems to be raining in parts of Lagos, I'm sure that after you've gone through this webinar with the brilliant speakers we have, you'll feel a little bit warmer about the future. Thank you very much also.
Thank you very much, Mr. Teslim Shitta-Bey. I expected nothing less from you in terms of giving us a very incisive welcome to this conversation. It's very clear that there's need for a clear orientation on use and trust. There's a lot to learn from, and we need to really plan For all those joining us now, you're welcome again to our personal finance webinar, Wills and Trust, Planning for the Afterlife. And I'm very intrigued at the fact that we're already receiving comments and even questions from participants, which means that this is going to be very, very engaging. But we will now go on a break, and when we return, the conversation continues.
Planning for the afterlife. Focus on wills and trust. In this report, we answered the following questions. Who should plan for the afterlife? Why should you plan? When should you start planning? Who should you talk to when planning? What is the role of the individual, trustees, and beneficiaries? We also gave insights into the concept of estate planning, the importance and myth around estate planning, estate planning mechanisms, the legal framework around estate planning, a step-by-step planning guide, a typical process involved after the death of a loved one. Download the report via the link showing on your screen.
Welcome back, and I want to take you to a very interesting session where we'll have the speakers making their presentations. And for all of you participating, you want to take notes. And like I said, if you want to ask a question, use the Q&A icon to ask your question. Like I said, we've already seen at least 1 or 2 questions already, so it shows you how interesting this is going to be. But before we get into the first presentation, we'd just like to take you to a poll. It's important for us to also have polls just to catch your polls and your views and perspectives around these issues of estate planning, wills, and trust. So it's a very straightforward question. How much do you know about wills and trust? This webinar is about wills and trust planning for the afterlife, but do you have a clear knowledge around it? So the options are very much, fair amount, no idea. So you have the opportunity to select one of the options so we can also get a sample of your understanding or your perception of what you know about wills and trust. It will surprise you that no matter how wealthy some people are, exposed even to academic levels, there's still some level of ignorance about the value of having wills and trust or even estate planning. Developed markets like the US and UK have evolved, but there's a lot of prospect, like Mr. Teslim said, for Nigeria and Africa. So the pool is on for you to participate. Please do participate so that we can get the feedback on this. This will really help also for our speakers, and we can even have further conversations around that. So the question again is, how much do you know about wills and trust? The options are very much, fair amount, no idea. Please select the option that fits the level of understanding. It's important to help us also. So all our participants are joining, and this is a personal finance webinar discussing around wills and trust, planning for the afterlife. We are at the stage of a poll before our first presentation, so you're not late if you're joining. I just wanted to know how your orientation and understanding about wills and trust. So how much do you know about wills and trust? The options are very much, fair amount, no idea. Just participate, and we'll be very glad to get your views and understanding. So definitely, polling results will get it in the course of our conversation, and it's now time to move on to our very first presentation for this webinar. I like this one. It says, facts, fear, and fiction, understanding estate plan. Like Mr. Teslim also said, you know, when you ask wealthy men, top people in the country, Nigeria, Africa, most of them tend to be worried why you're asking them to prepare their will for their estate plan or trust. But this presentation will help to clarify that concern or fear. But here is the polling result from our first poll for today. How much do you know about wills and trust? The people that say very much is 6%. 6% say they know very much. The fair amount is 76%. No idea is 21%. So our speakers, of course, you now know the level of understanding of our participants, and that should be a good representation so far, at least, because fair amount means there's a lot of work to do in terms of enlightenment, in terms of improving the orientation, in terms of what are the products or what are the things available to derive value on why people should really in wills and trust and estate planning. It's not a death sentence like Mr. Teslim said, it's just planning for the afterlife. But it's very important that we take note of that. So thank you for all those that participated. Thank you very much. So to present this interesting topic, fact, fear, and fiction, understanding estate plan, is Ibidolapo OLUFADE. He's the trust and legal officer of Meristem Trustees Limited. You must have seen the adverts there, transgenerational, interesting adverts they presented there. Now, Ibidolapo has worked broadly on trust and allied matters in Meristem Trust, where he has hands-on experience in private trust services, issues of wills, living, testamentary trust, family office setup, and issues around estate planning. So I think it's well-vested experience to give us an insight into the issues of understanding estate plan. He's also active in corporate trust space, where he routinely is involved in structuring collective investment schemes, bond issuance, custodial services, escrow agency, amongst others. I also like the fact that he's also a consummate corporate governance expert, because it's very important. Corporate governance about issues like this. So I would like to yield the floor down to him to give us his presentation, and welcome on board. Thank you very much.
Good afternoon. It's a huge pleasure to be here today. And I also consider it a privilege to be a part of the esteemed panelists for today's webinar. As it's put up here, my topic is around fact, fear, and fiction, understanding estate planning. So I'll be diving right into my presentation. One of the terms or acronyms that we are now familiar with in this world of ours is what is called VUCA, V-U-C-A. I think it's a term that is borrowed from those in the core financial space and wealth management. And when we talk about VUCA, V-U-C-A, we're talking about volatile, uncertain, complex, and ambiguous. And one thing we have experienced in 2020 up to 2021 is that what we call the VUCA or volatility, let me use that word, is not just limited to the realm of financial management. It's also what is applicable to our everyday life. Teslim was talking about the issue of debt capital and all in his opening address. And we can see that, for example, volatility has made it very terrible, such that assets are not being managed effectively because of the change in the environment, especially in terms of regulation and a whole lot. We now have a whole lot of debt assets on our hands. And again, when we trace this back, we also trace it back to the fact that there is poor wealth management, especially in the aspect of asset transfer. And then also the issue of uncertainty of human life. I mean, the pandemic showed us that, and it brought it to the fore that there's a lot of uncertainty. And then the environment is becoming more complex. We now see the democratization of artificial intelligence, technology, digital space, where you now have new asset classes. Now we are talking about crypto assets. We are talking about non-fungible tokens. People are passionate about their YouTube channels, their Twitter accounts, because these are their digital assets. And so there is now complexity in that space, which has now engendered new asset classes that people need to plan for. And so there's also the issue of ambiguity that this has also brought in about how do we regulate and how do we plan for these new asset classes, and even for the existing laws on estate plan. For example, everyone is aware of the general rule that you have what is called a testamentary freedom to have a will. But again, there's also the fact that your testamentary freedom is not absolute, may be restricted based on custom or your religion. And so there's that issue of, okay, which is which? This then makes it important for people to have expert knowledge in this area. And so in the midst of all of this, new facts, fear, and fiction have then emerged that I believe that it is highly important for us to discuss here today. Now, I already mentioned VUCA, VUCA, volatility, uncertainty, complexity, and ambiguity. And with volatility comes vision. You will not be here for life. And so what are you planning for the afterlife? And then with uncertainty comes understanding. I mean, there's a whole lot of uncertainty in the space. You need to understand the estate plan. You need to understand the tools that are at your disposal. And with complexity, then we need clarity. And that is why we are here today, to provide clarity to teaming people out there who are concerned about leaving a legacy. And because because of ambiguity, there's agility. You need to be agile in approaching the expert. You need to be agile in bridging the knowledge gap that you have concerning the estate plan, such that ambiguity of whatever it is in the law would not wreak havoc for your estate. Now, it's important that before we talk about estate plan, we need to understand the wealth management transition. So, I mean, for most people, you realize that the first stage of what is called broadly wealth management is accumulation of assets. You acquire asset, and then you then think of preservation of the asset. Preservation could mean portfolio rebalancing, risk management, planning for your retirement, and all of that. And then there's a bit on transfer. But interestingly, one of the things we've experienced in this space is that all of this process may work at the same time. So as you are thinking about accumulation, you are thinking about preservation, you're also thinking about transfer, because no one knows tomorrow, because you may be at the stage of accumulation, and because of the uncertainty in this space, anything happens. And then your loved ones are then left in the dark. I mean, a whole lot of issues are there. So it's important that even though there are these stages of the wealth management process, the accumulation, preservation, and transfer, at every stage that you are in, it's also important for you to think about transfer, which is the end goal in all of this. And so today we'll be looking at the different estate planning tools, the transfer tools that you have, and also the fact, the myth, and the fiction that people have around estate planning. So the first fear here is the D word. So we're all familiar with that truism that says that death and taxes are the two certain things. And so one of the fears that people have, you'll be surprised that people think that when they start planning for their estate, that is more or less a death sentence, that there will be no more. But also in our experience, we've seen that as well as for most of our clients who have put an estate plan in motion, they are still alive and kicking. So this is a fear that has no basis in logic at all. But again, it is also one factor that keeps people away from planning for their estate. Also is the issue of control. For example, one of the efficient estate plan too is trust. And so for most people, they do not want control to be wrested from them. So they think about the fact of, okay, why should I transfer my asset to a trustee who manages it for my beneficiary? So a lot of people, it could be as a result of distrust or the knowledge gap around the issue of letting go some assets that would be put into trust. And also there's the fear of cost. So when people think about estate plan, they think about, solicitor fees. I mean, a whole lot of these issues. And then some of these fears then put people away from planning for their estate as early as possible. And then more importantly too is the issue of family ties, the fear of divorce, the fear of a prodigal son or daughter frittering wealth away, the fear of, okay, what would happen to an incapacitated, I mean, a whole lot of issues around family ties that then makes people to think that, okay, is this what I actually want? Or would any of these two really allay whatever fears that I have around my family? And then what are the fiction? I mean, the first fiction here is that estate plan is for rich people, which is a big fiction. It is not true at all that estate plan is for rich people. Wherever you are on the economic ladder, you need to plan for your estate. And let me quickly mention, let me go to the fact that the number one factor I mentioned here is the fact that you own assets. And so Whether you are a retailer, whether you are a mass affluent person, whether you are an HNI, whether you are UHNI, you own assets. And one of the things we do at Meristem, and one of the things we even look at is the fact of intellectual property, for example. So you have artists, you have people who do not have the fleet of cars, who do not have the houses, who do not have the monies in the bank. But for example, they have their intellectual property. They have copyright, they have patent. And these are things you can plan your estate around. And for most people in Nigeria, they are not aware that your estate plan can cover your intellectual property assets. So there is something that you own. It's not just for rich people to use the mechanism that estate plan affords. Then the other issue is that young people don't need it. I mean, it is further from the truth. Remember, I mentioned VOCA. The world is uncertain. There is this word that says, remember your mortality. Mortality knows no age. So it isn't a question of you being elderly or you hitting the age of 70 or 80 before you start thinking about estate plan. Yes, we agree that people who are old, people who are elderly, they are the ones who begin to think about, oh, what do I leave behind? But again, young people need it. And the interesting thing about most of the estate planning tools is that you can always amend, you can always revoke, you can always add to, you can always alter. So even if you have an estate plan right now, that doesn't prevent you from making necessary changes to it. And then the other thing is people think, oh, it's all about death. I mean, when you talk about the estate plan, oftentimes, even for us at this side of the table, we always talk about death and all of that. But no, what about incapacitation? What about the asset protection bit of it? For example, trust is not just an asset transfer tool. It's also a form of asset protection. So it's not all about debt. And remember, we talk about volatility that has caused a whole lot of debt capital. So when people understand that, for example, having a trust is a tax planning tool, is also an asset planning tool. It's a tool for you to provide for what happens in the event that you are sick and all of that. People will then realize that it's not just about death. It's not just about where you are not here anymore. Another fiction is that, oh, my spouse will automatically get everything, or my family will automatically get everything. You should remember that if you do not have a will, the distribution of your asset is subject to the AEL, the administration of estate law, depending on the type of marriage you had or the kind of law that governs you. Whether if you are under the Act, the AEL would apply. If you are subject to customary law, then we may look at your different custom. So nothing is automatic. So it's important for you to have this at the back of your mind and then plan accordingly. And then especially for will, there's a fiction that once I have a will, I put pen to paper, then it's beyond challenge. I mean, nothing is beyond challenge. There's a possibility of challenge, and that is why it's important that you cross your T's, you dot your I's when you are having your will written. You meet experts who are able to advise you accordingly. And so what is the fact? I won't go about number one, which is the fact that you own assets. Everyone owns assets. And then your plan can always be revised. I mentioned this already when I was explaining why young people need it. And also the D and T words is the fact that debt and taxes are certain. And so estate plan is also a way to plan around your estate. So for example, most people are not aware that after your demise, when probate is being processed, you pay an estate tax to the state government, 10% of all of your assets. I think some few months ago, there was a story about the Samsung family, I think the death of their patriarch, where it was reported that the family will pay the largest inheritance tax in history, going to billions of dollars that they will pay for inheritance tax. And so for most UHNI in the US, for example, they use the trust mechanism, deed of gift, philanthropy to plan around this issue of tax. So it's also important for you to bear that in mind, the fact that death and taxes are certain, and so you can't escape from these two issues. So now we talk about estate plan because the general theme of today is wills and trust, planning for the afterlife. And so it's important for people to understand what estate planning is, and then to understand the twin tools, that is will and trust, that will be the focus of today's discourse. And so what is estate? So estate is not that gated community that you live, wherever you may be. So estate is the totality of your property, real and personal. And if I may also add, corporeal and incorporeal. Corporeal, that is those you can touch, that you can feel. And then incorporeal, those assets that you may not touch and feel, your shares. I mentioned digital assets, your crypto assets, People are talking about non-fungible tokens now. Your YouTube page, yes, people monetize this, you understand? And so these are the totality of your asset, it's your estate. And we know what plan means. And so when we talk about estate planning, we are talking about the process whereby you arrange your wealth and asset for your legacy. How do you ensure that the person you want to get whatever gets it at the appropriate time? Who gets what? When do they get it? How are they to get it? You understand? Who would be the driver of my estate when I'm gone? In this case, I'm talking about your executor or the protector of your trust. So these are all part of your estate plan. And importantly, it's also a plan that ensures that third parties, those who you would ordinarily not want to be in your affairs, are not there to poke their nose into how you want things done. And so that's basically what estate plan is. Once you understand what your estate is, you understand what it is to plan, and then you have estate plan. And so when you are talking about estate planning, more or less, some of the questions we are asking is, what are the transferable assets that you own? And like I said, these transferable assets, because of the complex world that we live in, they are now so diverse. So your cash, your jewelry, your artworks, your shares, your RSA, your crypto assets, these are all the assets that you can transfer. What do you want to outlive you? What are your legacy intentions? Importantly, too, when you're talking about estate plan, it's not so much about what you give people. It's also about your legacy. So is it your legacy to build trees around Lagos State? And in that case, you can settle a charitable trust. Do you have a school that is not for profit, and it's a form of philanthropic gesture for you? So your legacy intentions is also very important, as well as probably the assets that you distribute. So what are your legacy intentions? So when you're talking about estate planning, it covers this. And then also, who do you want to leave your legacy for? Who do you want to take over whatever legacy you currently have? And which the legacy to may also include properties, assets that you want to give out to. So who do you want to leave this legacy to? So these are broadly some of the questions that you agitate in your mind when you are thinking about estate planning. And so what are the estate planning tools? Yes, we'll be drilling down on wills and trusts today, but probably for the sake of further discussions another time, you should understand that deed of gift is one of the estate planning tools. Having an SPV, a special purpose vehicle, is an estate planning tool. Nominating a fund nomination as estate planning tool. Having a life insurance. But today we'll be looking at wills and trust. That's the broad theme of today's webinar as your estate plan, your estate plan tool. So what is a will? I mean, almost everyone knows what a will is. We may not have that deep understanding. If anything, Nollywood has exposed us to what wills are and all of that. We are all too familiar with that scene in a typical Nollywood movie where a person dies and then a will is read in their living room and all of that. Whether that is the case, we'll know as we proceed here. So, but basically, a will is a document through which a person directs how his properties will be distributed upon demise. But it does beyond that, beyond just distribution of assets. It's also a document that appoints your executor. It's a document that appoints a guardian, for example, if you have infant children. So it's a document that tells when, how your assets should be distributed. As a matter of fact, it can also be a document that embodies a trust. In that case, you are talking about a testamentary trust. So broadly speaking, a will does a lot. And so, so as you have a will, you then have also what is called a trust. For those who are also thinking in line of having a trust. So a trust is, simply put, an arrangement whereby one person called the settlor transfers their asset to another person or entity called the trustee for the benefit of an individual or individuals called beneficiaries. So in short, you have three parties to a trust. You have the person called the settlor, who could be you and I, who is transferring assets to a person called the trustee for the benefits of those we call beneficiaries. And so for your trust, it would be a living trust or a testamentary trust. Shortly, a living trust is an arrangement whereby while you are alive, the trust is operational. you see how it is being run. While a testamentary trust is a trust that kickstarts after your demise, oftentimes it's incorporated into a will, which means that it goes through the probate process. And just shortly, in having your will, what are the things that you need to look out for or put in place? Number one, it has to be in writing. You have to sign it. It has, you need to have witnesses who will witness your signature and who would also sign as witnesses. It has to be lodged in the probate registry. And then don't also forget, importantly, you must appoint executors to that will, because they are the ones who will then take step after you are no more to obtain probate, or what is called proving of your will. And so for a trust, the process is seamless. As a matter of fact, the trust could be oral or it could be in writing, but oftentimes where the type of asset you have may shape the form that your trust may take. There's the belief that if you are thinking, if you are transferring real estate, it's important that the trust is in writing. But generally speaking, you would always advise that the trust should be in writing. So like I mentioned, you have the three parties, the settlor, the trustee, and the beneficiaries. And then you make your instructions known. The instructions are reduced into a document called the trust deed. Your trustee may also take it upon themselves to stamp it at the FRS. The document is kept. You appoint a protector who would ensure that your instructions are complied with when you are no more. Now, the choice of the tool to go to can be influenced by different factors. So there are people who are content with just having wills. There are people who think that, okay, having a trust is just okay for them. And there are people who have a will and a trust, which could be, the will could be a form of a pour-over will, and the trust could be a form of a testamentary trust. And so for most people, when they are making that decision, they are weighing the pros and cons of having a will. For some of them, it is some of the circumstances of their family life. That is what would determine what to have. Do they have infant children? Do they have income generating assets? I mean, a whole lot of these factors may then influence which to go for between a will and a trust, or even to go for both. So, but just to run down, what are the advantages of having a will, for example? So, so there is what is called the testamentary freedom. So with a will, you are free to give anything to whomever you want to give it to. But it should be borne in mind that with this freedom, there's also the limit to that freedom, or what is called restriction to testamentary freedom, depending on where you are from. For example, if you are from Edo State, Benin, specifically, there's a restriction to your testamentary freedom, especially as it touches on some specific property. If you are a Muslim, so there is the Islamic law restriction to your testamentary freedom. And also one advantage of having a will is that you can appoint a guardian if you have infant children who are not of age, or a child with a special needs child, you can appoint a guardian in your will to take care of such. And then importantly, you appoint an executor. So it will give you that opportunity to do that. And then you can also create a testamentary trust. Remember, I mentioned that there are two types of trust. There's a living trust, that is the trust that is operational while you are alive. And then there's what is called the testamentary trust. That's a trust that kickstarts when you are no more. So in your will, you can then set out instructions about trust. You can entrust property to a particular person to manage it for beneficiaries that you have in mind. And also one advantage of having a will is that it can be amended or revoked. And this is why it is appealing to people across various demography and age. So even if you are 30 or 25 now, you can still have a will. You can amend it through codicil as you grow and as you acquire assets. So one of the disadvantages of the will is that there are possible challenges to it. There's also the restriction to your testamentary freedom, depending on the applicable custom and religion. Then the process of going through probate, at least the process of probate may take you between 4 and 6 months. And so within that period of time, your beneficiary may not be able to access your assets. And then there's the estate tax bit of it, where you have to pay 10% estate tax. So for some, that may put them off to say, oh no, I don't want this. Then for a trust, so one of the advantages of a trust is that it avoids the probate process. So that 4-6 months, and if there is a challenge to that, to a will, it may go beyond that. It can go to years and all of that. So for a trust, it avoids that probate process, which is a relief to a lot of people. And then you can see how your assets are being managed during your lifetime if you have a living trust. As a matter of fact, the settlor can even be the beneficiary of the living trust. So oftentimes we have clients who are settlors and also beneficiaries. And then their secondary beneficiaries will only start to take benefit when the settlor now, the primary, who is now the primary beneficiary, is no more. And then asset transfer, that is transferring asset to the beneficiary, is faster with a trust, because you are not going through the probate process, you are not going to the registry, reading out your will, applying for probate. None of that is applicable for a trust. And then privacy is ensured. One of the key obligations of a trustee is confidentiality. And so when you have a trust deed or any trust arrangement with a trustee, rest assured that privacy is ensured, confidentiality of your business, of your circumstances are also ensured. So people want that privacy. And then restriction to testamentary freedom is limited. So it's a great appeal for people to have a trust. But again, it also has its own disadvantage. So it's about weighing the pros and cons. So one of the disadvantages for some people, I mentioned it, that some may not want to release control of their asset. So for a trust, it entails legal transfer of asset to the trustee. So the trustee is now seen as the legal owner of the asset. And it may be expensive to execute, especially transfer costs. Now, one of the things about a trust is that when you set up a trust, you still need to go through the process of transferring your asset. And I think this is one of the things that we need to broadly look at in Nigeria, that, for example, is it possible by regulation to ensure that the trust deed is just thinking, I mean, this is part of the broader discussion. It's a registrable document, for example, because one of the things we have in Nigeria is that when you have a trust deed, you still need to go through the process of transferring the assets. So for example, if it is real estate, land, for example, you need to obtain the consent of the governor to transfer such real estate to the trustee. So is it possible for us to look at the Land Use Act and provide an exception to that for trust instruments? So these are broader conversations that we can have. And these are some of the issues that may put off clients. I mean, in discussing with clients, some may feel like, oh no, I don't think I want to transfer my real estate, because the whole process of the bureaucracy of getting governor's consent and doing all of that, it's an issue. Also, transfer of shares. You need to liaise with CSCS, registrars, the brokers, and all of that. So that may take some time. And so these are also broader issues that we may need to look at. And it also goes to the fact that we have a dated trust act or trustee act in Nigeria, I think, which we got as a result of the statute of general application. So it's important that we have a trust act that is fit for purpose, a trust act that is modern in all respects. And then if you have a small estate, the cost may outweigh the benefits, especially if you do not have income generating assets. So you may need to start paying out of your pocket for the management of that trust, for what the trustee is doing in managing the asset. And so when you look at it broadly, a robust estate plan, although the conversation is about wills and trusts, but a robust estate plan, especially depending on your objective and your needs, may lean on different things. So you can have a pour over will. So for example, you have a trust, and we do this for our clients a whole lot, especially for those who see the need to have it. So you have a trust, and you have settled the trust with assets and all of that. Maybe all of the assets you think you own, you put them under the trust. But in time, you may also have other assets. And so some, they have a will, and in that will, there's what is called the residuary clause or the residuary estate clause, whereby you then state that all your residuary estates should go to the trust that you already have. You mentioned the trust and all of that. So that is an example of a pour over will. So some may even list all of the assets, not just restricted to the residuary estate now. And then they say that at their demise, all of these assets should go into the trust. So that's called a pour over will. That is, assets under that will should be poured into that trust. So that's an option for people. Then there's this testamentary trust option where you create a trust from a will. You still have to go through the probate process, but the beautiful thing about having a testamentary trust is that you have the option of then choosing a trustee that has business acumen, a trustee that that is of repute to manage assets for your beneficiaries. Executors may be busy and all of that, and so some may just want to have a trustee to manage those assets, usually where maybe charitable causes are involved, such that, because for oftentimes you know that trustees in Nigeria are companies, and so there's the perpetual succession bit. So they then want someone who would continue to manage these assets on their behalf. And then you can have a fund nomination. Recall that I mentioned that to get probate in Nigeria, you may look at 4-6 months to get your probate out. And so within that period of time, your beneficiaries may not have access to your assets. So you can set up a fund nomination where you nominate someone to get funds that you have in an organization. So that is mostly limited to cash. So that's an option where you can, in the meantime, take care of your beneficiaries. So what are the assurances and protection for a settlor? Because I deliberately created this slide for trust because, like I mentioned, it's a very big deal for people that is transferring their asset to a trustee, who then becomes the legal owner. And they feel like, why should I do that? But there are assurances and protection for settlors. So number one is the fact that you can appoint a protector, so that when you are no more, so that fear of probably the trustee taking over your asset is allayed. So there are protectors who more or less play oversight role over the activities of the trustee. Secondly is the fact that, you see, a trust relationship is what is called the fiduciary relationship. It's a relationship of good faith. And so a trustee is always bound to utilize assets for the object of the trust. If a trustee goes against the instruction of the trust deed of the object of the trust, that is a misconduct that the trustee can be punished for. So this is also in addition to you appointing a protector. You can also appoint a successor trustee, such that in the event that the trustee can no longer act for whatever reason, the successor trustee comes in and then takes up from wherever the trustee is left. And then there's bankruptcy protection for most organizations that are regulated by SEC. So for trustees in Nigeria, they are regulated by SEC. And so there is the bankruptcy protection bit, especially in terms of transferring the assets and liabilities to new entities to continue from where they are left. So yes, there's some assurance for the settlor. And so with the world growing more vocal, that is things becoming volatile, uncertain, complex, ambiguous, the worst is not to take action at all on what will matter most. And as has been rightly mentioned, the best time to take action for tomorrow is today. So we would employ everyone to take action on what is actually important, and that is their estate plan. Thank you very much.
Thank you very much, Ibidolapo OLUFADE, Trust Leader Officer of Meristem. I think you really gave us a very elaborate orientation and education on estate planning, wills and trust. One of the big takeaways for me is that it is not only for the rich, like you rightly said, Nollywood. I mean, our creative industry will have to learn more about the rich people, whether it's in Hollywood or Bollywood and across Americas. It's for young people too. It's also the fact that you can have intellectual properties assets in that category. And I remember the legendary Fela and his family have used that IPSS collaboration to really keep on its legacy. So there are opportunities in that area. And also you talked about the need for having an enabling regulation that looks at the issue of trust. For example, is it a registrable document that can be used? And also the fact that the transfer of shares process needs to be enabled. Those are issues of immense concern that has to be addressed. Thank you once again for this very incisive conversation, and look forward to the Q&A based on what you shared. And I believe other co-panelists have also learned and have their notes. Just to let those who have joined us, of course, this is the personal finance webinar. We are looking at wills and trust, planning for the afterlife. We are going to move on now. But don't forget that you can send your questions to the Q&A chat box. Please don't forget that you can send your questions to the Q&A chat box. We've seen some questions already, so it's interesting to be part of this. But well, let us take the second poll. I'm so happy that Ibidolapo has let's say, shaken the table. There's not only for the rich. So people say, wills and trusts for the rich people. It's also for young people, for planning, like Teslim said. So I hope the millennials and a lot of young people have joined, have taken note of that. So our second poll is very interesting. It says, how important is a lawyer in planning for afterlife? How important is a lawyer in planning for afterlife? You may have notions about lawyers, but they're very critical. So I'd like you to respond. Very important, important, or not important. I'd like you to respond with your answers to this poll. We have lawyers as panelists here, so they will get the feedback. But for me, I know that lawyers are very important. I mean, right from childhood watching movies, you see the wills, lawyer is reading the will and the trust. Ibidolapo talked about trust. You know, the former president of the US also did the trust. I was going to ask about that one. Is it a living trust just to protect assets, avoid conflict of interest when he was president of the US as a businessman? But trust also needs a deeper insight and asset that people can leverage. So if you're joining us for the personal finance webinar, looking at wills and trust planning for the afterlife, we're in a second poll. We just finished a very interesting presentation. The question is, how important is a lawyer in planning for afterlife? Is it very important, or is it important or not important? We'll be pleased to get your feedback on this. And still on the first presentation, dealing with the fear and fiction and the facts. I like the fact that Ibidolapo highlighted the VUCA, the issue of volatility, uncertainty, and the issues of complexity and ambiguity, those VUCA, but he also gave us a solution to that, which is very, very interesting and instructive. The solution is that we need to have vision, understanding, clarity, and agility. And so I believe we've taken that feedback. So let's look at the result of the polls. It shows that very important in terms of the role of lawyers in planning for the afterlife is 66%. Important is 29%. Not important is 5%. So Ibidolapo and of course, Kolawole, Yvonne, you all know that the lawyers are very important and critical. I know Mr. Teslim is smiling at that because we really talk about lawyers really setting that pace, and of course, the other fields and sectors will take on. So lawyers are very important in planning for the afterlife. So for everyone participating here, we now know that lawyers play a very critical role in this space, and we also need to engage them. So whatever class you are, it's not just for the rich, it's for all classes. You have assets, you have plans, you need to engage sense of a lawyer for estate planning, wills and trust. So now move on to the second presentation, which facilitated by Yvonne EZEKIEL. She's the managing partner of Olisa Agbakoba legal firm. The topic for this course is estate planning with wills and trust, the legal perspective. Now we know that lawyers are very important in planning for afterlife, so it would be nice to hear her perspective. She's leading the international trade practice group, focusing on trade controls, trade litigations, while helping clients to understand how government policy activities and address compliance matters are very critical. She's also advising on the nexus between politics and the spheres and how they impact the dynamism of companies and their activities. She has held various positions within the British America Tobacco Company, and also she's been in human resource transformation, involved in bank transformation agenda, like Diago. She's also had experience in business, and she has been key to the organization of the Olisa Agbakoba legal firm into a world-class law firm supported by the Processes. And she, of course, is a member of the Nigeria Bar Association. So I'd like to welcome, to take this presentation, Yvonne. I yield the floor to you.
Thank you very much. Thank you very much, and welcome everyone. And it's indeed a privilege to be part of this conversation, a very essential conversation at that. And listening to Dolapo, I was saying to myself, well, is there anything else I need to add? Because Dolapo did very good justice to his presentation and talking about wills and estate planning and the rest. Like we all have said, when you talk about wills or you broach the topic of a will, automatically everyone sees death before them, or they begin to think you're willing death for them, and it's almost as if it's a death sentence. But like we've all acknowledged, it's all about estate planning. We've worked so hard during our lifetime, or at least most people are working very hard during their lifetime, and it's only proper that, you know, that they decide how that their riches or their wealth and all that they've worked for is distributed in a way and manner that they desire, and that the people that are actually intended to enjoy all of that actually do get to enjoy it. So let me just quickly share my screen. The first big question is, what is a will? Essentially, it's a legal document that expresses a deceased person's wishes as to how his wealth should be distributed, how his affairs should be handled upon his death. So and it could be anything from, you know, the cash he has, to a vehicle, to land, to a house, to jewels, to anything, basically any asset that they have. So you essentially spell it out as to how you want that distributed, who gets it, who doesn't get it. I mean, I've seen a will where it's been actually spelled out, I don't want Mr. XYZ to get anything from my estate. So it could, so while you're also providing for certain people, you're also deciding who should not enjoy out of that will for whatever reasons. And the most important thing to also note is that the will becomes active only upon the death of the person who's written the will. So what are the features of a will? So it's very important that, you know, that people understand what the features of the will are, because if you do not include some of these things or be mindful of some of these elements I'm going to talk about, it's likely to invalidate the will that you've written, meaning that therefore your wishes probably will not be carried out because somebody can contest and debate and therefore render your wishes invalid. So first, it must be in writing, very clearly stating what it is that you want. And it's also important that the testator, that's the man who writes the will or the woman who writes the will, must have done that voluntarily. So you wouldn't have written it under duress. You are obviously in the very sound mind when you decided to put pen to paper and write down your wishes and your desires as to how you want your estate to be distributed. Okay? Now, it must be signed. So when we say it must be duly executed, what we mean is that it must be signed by at least 2 witnesses and ensure that it's duly dated. Okay? Now, the will should also describe the assets that you want distributed. So if it's a house, You'd say it's a house situate on number 10, Elaborate Avenue, or there's a car, my Mercedes-Benz car, registration number XYZ, my jewels that are in the safety box in UBA, whatever the case may be. You must clearly describe what it is that you are asking to be distributed upon your death. You must also name the executors of the will. So whoever you would like to choose as your executor must be named in the will, and you should have at least 2 people if you like. And of course, in the case of where you have minors, you still have young children, then you could also name who the guardians of these kids would be. And very importantly, when you're done with writing out your wishes and all that you need to do, ensure that the will is sealed and take it to the probate registry and sealed and left to the probate registry. Now, what are the benefits of writing a will? Because again, when you talk about wills, the first thing people begin to think about is their mortality. And it's really saying to people that it's a very good estate planning tool. So you're making your intentions known, and you will like that you obviously want those intentions followed. You're actually providing for selected people, family members, loved ones, your children, and you're essentially protecting your estate from predators who may want to come in and make certain claims on your estate. So you're essentially making your wishes and all to the benefit of people that we call the beneficiaries, people who are named in the will that should benefit from your estate. Now, some of the common mistakes that people make is that, first and foremost, some people decide that, I mean, we did a poll just now and 5% decided that, you know, we don't need the services of a lawyer. While that may be true, but I think it's important that you shouldn't draft a will without legal advice. And there are a number of reasons for that. Now, it may well be that you may be appointing, we talked about making sure you have executors of your will so that the guys or the people who would carry out your wishes upon your death. Now, if you decide you want to appoint a 90-year-old man or your friend who is 90 years old as the executor of your will, it's most likely that he might predecease you, and therefore that becomes a problem. So it's important that you appoint what I would consider appropriate executor. So probably somebody younger than yourself. Also, we also say, it's unadvised. We don't advise that you put your funeral wishes in the will. Some people also say, I would like to be buried maybe in my hometown, or to be taken to, to my village, or be buried in whichever way you want that to happen. Now, because the will doesn't become active until after the death, so it might not be advisable to put such instructions in the will. So we would suggest that you write a separate instructions for that, and so that it's not included in the will, as the will can only be opened and read upon the death. And very, very important is ensuring that after all said and done, after all your wishes have been written down in the will, the will must be taken to the probate registry to be registered and kept there. Now, we have known people to have kept their wills in a storage box in their house, under their beds. Wills have been kept with friends, which is not necessarily bad. Wills have been kept, some people probably live with their solicitor, but because you want to give validity to eliminate contention, eliminate anybody questioning the validity of the will, it's best to keep it at the probate registry. Because at the end of the day, no will can be executed without the probate granting, without the grant of probate from the probate registry. So in any case, so it makes sense that that's where it has to be kept. And it's sealed, you're given a receipt, the names of the executors are written on top of on the envelope of the will. It's sealed, stamped, and kept in the safe by the probate register. So it's the best way to sort of keep the will. So these are some of the common mistakes that people make when by not, going to the probate registry to store their wills and using the wrong executors for the wills. So talking about the probate registry, I thought it was very important that I quickly mentioned that what the role of the probate registry is, because it really is the judicial system that actually is responsible for settling the wills or trust, guardianships, and so on and so forth. It's because it's a process by which the will is looked at, is reviewed, is authenticated, and by the time it's administered and you've gone through all the process that needs to be done, then the probate then grants you permission to go ahead and execute the will. Whether it's intestate, when I say intestate, that's whether you died without writing the will or the person died writing the will. So if someone dies without writing a will, then what is then applied for is letters of administration. But essentially, whether you die intestate or not, it's the probate registry that grants, obviously signed by the chief judge of the state, that grants permission for the estate to be interfered with. And when I say interfered with, in a positive way, what I mean is for the wishes in the will to be carried out and it's executed. Now, the law actually even supports this. So if you look at Order 58, Rule 2 and Rule 17, using Lagos State, Lagos High Court rules, or the civil procedure rules, it actually suggests and recommends that, wills be kept in the probate registry. So first, any person may in his lifetime deposit for safe custody in the court at Lagos his own will, sealed up under his own seal and the seal of the court. Remember I said, when you take your will to the court probate registry, it's sealed, you put your seal is on it, the probate registrar puts its seal on it, and then it's kept in the safe. And every original shall be, amongst other things, kept in the probate registry in such manner as to secure at once the due preservation and convenience of the same, that's the will. And a copy of every such will and of the probate and administration shall be preserved in a book kept for the purpose in the registry. So once the will is written and it's taken to probate registry, that's where it's stored and it's entered into the register. So essentially, the Lagos State High Court rules, and not just in Lagos State, but generally the High Court rules nationwide, they have, and it's the same wordings, generally supports the fact that when wills are done, then you must bring it into the probate registry to ensure its validity and to ensure that it can be enforced appropriately. Okay, so probate without a will. So of course, if you do not write a will, essentially there's still a process you still have to go to the probate registry at this point in time. This is with a will. Now, for those who have written a will, like I said, the will has been, and we assume that the will has been lodged at the probate registry. Upon the death of the testator, the executor informs the registrar of the passing of the individual. Then the registrar and himself, so he notifies other family members or other people who should know, stakeholders of the estate of the individual, and they agree a date where the will will be opened in the presence of all of these people and read out to all of them. And when this is done, based on the contents of the will, and then they do an assessment of the total of the estate, and 10% of that is paid to the Lagos State government. If there's land, you have to go to the land registry, the Commissioner for Lands and Surveys and Registry, to ensure that you get the appropriate consent and governor's consent for the land. So just ensure that everything else is tidied up. If there are debts, then clearly that has to be settled first, and then whatever is left is then given to the beneficiaries of the will. But more importantly is that what the probate registry does is that it grants the executor the permission to carry out the wishes of the testator. So it's important that if you if you have wishes or desires and you want it carried out, then it's really important that this will is written and given legal backing by taking to the probate registry, who then grants the executor the permission and the powers to carry out the wishes as you set them out in the will. Now, even if you have not written the will, and we don't encourage that people do so, we encourage that for proper estate planning and for ensuring that wealth is passed down from one generation to the other, we encourage that wills are written. But if for whatever reason, and we've known lots of people who we think should have known better to write a will, we find that they do not, they haven't written a will. Now, that's not the end of it all. It doesn't mean that, that's the end of it all. So what happens obviously is that the next of kin, and for those who can prove that they are next of kin to the family member, to the deceased person, applies for letters of administration to be able to administer the estate, and then they go through the probate process of, again, assessing whatever the estate is, what the estate is worth, and paying the due fees to the state government, and then getting the final permission also to administer the estate, of course, less whatever liabilities that the estate might be carrying as well. Now, of course, to mitigate some of the challenges that people face with regards to wills generally, like I said, the first, of course, is not lodging the wills in the probate registry. And like I said, that opens it up to be contested. It may well also be that, because you're storing it or hiding it somewhere, and then in the course of time, it gets lost. So again, you've opened the will to possibility of forgery. So somebody comes up with a will and somebody else comes up with another will. So how do you know which is the correct one? Because it was never lodged in the probate registry in the first place, okay? So it's important that to deal with the challenge, one of the challenges that we face especially is making sure that wills are lodged with the probate registry. That, to a large extent, minimizes contentions, litigations, and wranglings within the family as to which one is the valid one. Okay. Then the probate registry from the administrative side, essentially, the probate registry is very manual, still manual. Things take forever. One of my colleagues was talking about losing her father and how it took 6 months for the letter of administration to come out. Apart from that, because of course her father didn't leave a will, her uncle had also gone to try and apply for it, while her mother had gone also to apply for letter of administration. So it was a toss-up as to who the registrar was going to attend to. But obviously, because the mother was the next of kin, so clearly she was the person that got the letter of administration. But then again, there's also the customary law to deal with. So the question is sometimes is where you have very strong customs that apply in certain communities. And I think Ibidolapo mentioned Edo State, for example, and I'll take Benin, where it says the first son, by tradition, the first son takes everything and is at his pleasure and he decides who gets what. So imagine that a man who's died intestate, and he has very young children, and probably more than one wife. It becomes a bit, because if you really have an errant first son who doesn't really care about the entire family, then it means they're going to be left destitute. So it's important that talking about wills, people realize that talking about a will does not mean that you're going to be dying the very next day. It's all about just making sure that you're taking care of making your affairs tidier, and you don't leave your family in a state where there's a lot of wrangling going on. So I've also mentioned how the entire probate process itself can be enhanced, or should be, because it's so manual And, as everything else in Nigeria, you have to sort of facilitate, by way of, a little cash here and there for things to come out, and it means that while that process is dragging on and on and on, what happens to the family? It means they're struggling, they're going through a tough financial times just simply because, they haven't gotten the probate to be able to distribute the estate as it should be done. So it's really important that wills are written, and you can decide which way you want to go, whether you want to have a will or you want to have a trust. So just to talk about matters that I think beneficiaries should also be aware of and things like that. Actually monitor the probate administration. So you can monitor how things are going. You shouldn't, be concerned that maybe you have no right to. You have, because you're a beneficiary, so you can monitor what's going on within the probate registry, how things are going on. You can also, obviously, if things have been, let's assume that the estate is free of liabilities, and so there's no reason why, therefore, the estate cannot be distributed as quickly as it should, and so you can actually begin to enforce compliance with the terms of those wills. So essentially, beneficiaries have some rights, is the point I'm trying to make. So, you can therefore question some of the things that are happening and ensure that there's compliance with the terms of the wills. So should you use a lawyer? Most certainly you should. It's very important, like I said, because your I's must be dotted properly, the T's must be crossed. If you don't have the right executors, if you don't have the right to state that people signing and attesting to the will for you, if you don't lodge the will in the right place, you're opening yourself up for debate, you're opening yourself for the wills the validity of the will to be questioned, and basically putting your family in penury. Because the idea about having a will is that you're actually planning financially for the financial security of your family, and the absence of a will would likely do the opposite. It might in the end help them out and provide for them, but it might be a long road towards getting to that security that you actually should have provided for them if you had obviously had a will put in place. So the second option then therefore is that, okay, so I might decide I don't want to do a will, so what else can I do? You could do a trust. And a trust essentially is really about just putting your estates in the hands of someone that you believe would help to manage your estate. And the key difference between this and the will is that the will comes to effect upon the death of the individual. That's the only time it becomes effective. But the trust can become effective immediately you sign the dotted lines saying that you are creating a trust. So it's essentially a fiduciary relationship in which the man who set up the trust gives a trustee the powers and the rights to hold the property and assets for him for the benefit of the third party. So it's also probably a way to avoid paying death duty or inheritance tax, as it were. I know in other climes, inheritance tax can be quite expensive. So this might be a way to then decide how to distribute your estate while you're still alive and ensure that you also can avoid huge inheritance tax. Okay? So a trust is active the day you create it, and the grantor may list how he wants it to be distributed. So he might say, well, he might decide, I want this property, I want my child to have this property and enjoy the proceeds from that property. It may well also be that, okay, so you're putting a company into that trust, and whatever is put into that trust, you're setting it up for people to benefit from it. And the key thing is that it is while you're still alive that happens. So the big question people always ask is, what's the difference between the will and trust? I think actually the key difference, like I said, is that one becomes effective while one is alive, while the other becomes effective upon death. So will is effective upon death of the man who has set up the will, and the trust is effective while you're still alive, okay? They are both estate planning tools, and they help ensure that your assets are protected and bequeathed to your heirs, and whether your spouse or your children, whatever the case may be. But the important thing for both of them is that they're key estate planning tools. How you want, whatever you want to do or which one you want to choose is essentially your choice. You can decide to have both. You can have a will, you can have a trust, you can have only a will, you can have only a trust. I wouldn't necessarily say one is better than the other. The key thing is that they're both estate planning tools, and that's the key benefits that they both have. I mean, if I own only one, I mean, it depends. If you have a lot of assets, it may make sense to use a trust to secure it, knowing that because of the size of your estate, you might be, your family upon your demise might be liable to pay huge inheritance tax or huge debt tax. So you may decide that, well, let me set up a trust and put all these assets into that trust while I'm still alive. And then it allows you, even when you're still alive, to see how your estate is being managed. Although it might be an expensive one to do because of transfer of those assets to the trust and to a trustee, but essentially, it's one way to go that may be beneficial to you while you're still alive, based on the huge assets that you have. Okay. So I mean, I think I've just talked about that in terms of deciding what to do. I said deciding between a will or a trust is really a personal choice. And some experts would probably recommend having both, okay? So, but what we do say is that nearly everyone should have a will. Not everybody needs to have a trust, but at least everyone should aim to have a will. And it's probably key, having that. So I'll just probably summarize and say that a will can be effective as an estate transfer tool, an estate planning tool. You, of course, ensuring that your loved ones are planned for. Whether it's a trust or a will, you're making plans for your loved ones. You're putting something into place to ensure that wealth is transferred in one way and another to the people you have selected, to your loved ones, to the beneficiaries. The only thing about the will is that the will is public. It's put in public domain. Once it's in the registry, it's public information as opposed to a trust, which it's private. But I think that doesn't really matter. What's important is the fact that you're putting something in place, whether you choose a will or whether you choose a trust. The important thing is that you're actually putting something in place that provides for your family, for your relatives, or for whoever you've chosen, whether it's child, whatever it is, but you're putting something in place that will ensure financial security for them when you're no longer there to be able to give them that security physically. So that's really what's important, and that's where I'll probably stop for now. Thank you. Thanks.
Well, thank you very, very much, Yvonne, for that exposition. I mean, it's very clear, understanding estate planning, wills and trust from a legal perspective. Quickly, you really said that there's need to have appropriate executors of the will. You've taken this clearly that lawyers must be consulted. They will always help in doing these wills and trust. Also, the value of the public registry, we're putting the documents in the public registry, the rule of the probate courts, and you also identify some of the challenges with wills administration. I think one big takeaway is that we need digitalization of the process, because digitizing that process will help to quickly clear the time spent concluding the whole administrative to also invoke their right to access information and timely receive their entitlement. Can also enforce compliance. It's very, very important. Thank you very much, Yvonne, for that very interesting expose. See how for you to respond appropriately. Also, to all our participants, we have giveaways. I mean, you know, events like this are always interesting, you know, that you're going to have a giveaway. So we have hard copies of news and trust reports with 5,000 naira each. So don't forget, just go to the chat box, participate in it. In terms of the opportunities there, don't forget to fill the form. Fill the form, you can participate in that. You can be a lucky winner if you participate. So we have an opportunity for you to make a good value from this event. I mean, 5 hard copies of the news and trust report is a good one for you. So please don't forget to go to the chat box and participate. You could be the lucky winner. Now let's get to the poll. The third poll for today is keeping a will, and we want to ask you the best place to keep a will for authenticity and safety purpose. Already, one has said some things, but let's get your response. Where is the best place to keep a will for authenticity and safety purposes? Just pretend like it's not this presentation. So just tell us where is the best place prior to now that your will. Is it in the bank? Is it in a lawyer's office, probate registry, or in your house? We have these 4 options. I'd like you to rescue them. The best place to keep a will for authenticity and safety purpose. Is it the bank, lawyer's office, probate registry, or in the home? So I'd like to hear from you. Where's the best place? And then please, I'd like to make some clarifications for our giveaway. It's 5 hard copies of the wills and trust report that is worth 5,000 naira each. Okay, so I know that some people are like, they must have heard. So I want to clarify that we're giving 5 hard copies of the wills and trust report worth 5,000 naira each. Don't forget to fill the form in the chat box, and you could be one of the lucky winners. You'll be selected randomly at the end of the session. So just stay tuned and be part of this conversation. So we're waiting for the feedback from the third poll. Yes, it's coming on now. And yes, we have it. So the best place to keep a will for safety purpose, for those that pick the bank, we have 19% of people that choose the banks, lawyer's office 3%, probate registry 78%, and interest for the home 0%. Nobody wants to keep it. So that's an interesting feedback on the poll. I can see Yvonne, Kolawole, Ibidolapo, and Teslim, and all laughing the same response. So we'll now move on to our next segment. This is also another interesting presentation. We hope that participants are enjoying this, and of course, I've seen over 7 questions, so it's interesting to get to the Q&A session. The next conversation is around planning for the afterlife. There are 2 certainties, death and taxes. So of course, you have to prepare for the afterlife. To lead us in this conversation is Kolawole OLANIPEKUN. He's a senior associate and head business development stack legal solicitors. Kolawole is an avid legal practitioner and is renowned for being very vibrant and a tech enthusiast. I like that. He's a tech enthusiast. So we're indeed in the 4th industrial revolution. We'd like to hear his perspective on the relevant trends in the legal profession. He's also vast in financial services and various aspects of commercial practice. It's also very good skills at Ghana. On the international scene, he has worked with the International Maritime Organization and in London carrying out significant research of marine pollution in the maritime field. That's something that Mr. Teslim called the blue economy. So I think it's legal in that area. But OLANIPEKUN will be taking this next segment, and it's a very important segment. So I'd like us to be very active and listen attentively. I yield the floor to Kolawole for this presentation.
Thank you very much for the introduction, Mr. Ottoabasi. It's been an honor and a privilege to be here as well. I spent the past 1 month working with the Proshare team on this report, and it's coming at a very, very important and vital time. basically, our esteemed panelists have already touched on most of what this report is, intends to cover. But I would just more or less just take us through more or less like an overview on all the various segments and important aspects that the report touches. So basically, sorry, just trying to, yeah. So basically, the report is broken down into 5 parts. The first part basically is an overview. It talks about wills, and it just takes us into the concept of wills and the importance of wills and trusts. The second part of the report looks at the various parts that's involved in planning a will, clarifies issues that has to do with why one needs a will, who needs a will, when a will, when you start planning about a will, and then it also clarifies issues around estate planning of the wills or the will writer's properties, management of the deceased assets, both fixed and movable. And then the third feature, also features about planning for the afterlife. It talks about the contributions from legal practitioner, talking about how to plan a will, and then the common mistakes that we often make as lawyers when drafting wills. And the fourth section of the report also now focuses on what beneficiaries ought to know. Rather than flying around blindly trying to find direction, the section lists, lists out the process of addressing issues related to a deceased wishes. And while the last part of the report is more or less like a conclusion. So what I'll just do is, through the slides, I will go through each of these one after the other. Most of these things have already been touched on by our esteemed panelists, particularly Mr. Ibidolapo and Mrs. Yvonne. So, but I will just quickly go through that in a bit. So the first part of the report, talks about, a very important issue, which is who should actually plan for a will. Basically, we have the Wills Law of Lagos State, as well as the Wills Act. And based on the provisions on the Wills Law of Lagos State, what it says is that it includes that anyone can plan the arrangements of your afterlife affairs. And then it now further states that every adult who has attained the legal age of 18 years. What that means is once a person is deemed to be an adult, they are effectively able, to plan a will. But there's also a very important exception to this, and the law further goes to state that seamen, mariners, or crews of commercial airlines, do not necessarily have to meet this requirement because of the hazardous nature of their job. So what that means is people that work, at hazardous jobs, people that work in commercial airlines, seamen, have an exception of planning for a will before they attain that age of 18 years because of the hazardous nature of their jobs. So they don't have to wait till they attain the age of 18 years. So essentially, you can have a crewman or someone, a part of the crew of a commercial airline younger than 18, in theory, having to plan a will. But basically, it is advised that there are specific categories of people that to plan their wills. And these are married couples. Traditionally, a spouse would likely inherit a deceased person's things if she dies without a will. But these are things that one should not necessarily be left to chance. And if one is a parent, you have to also think about your children as well. So parents that want their kids to inherit after their spouse need to put that in writing so that there's no room for any error of interpretation by the courts. And now we also have single people who do not have kids but have a very high net worth. So the definition of a high net worth is quite relative, but we decided to just put a reasonable estimation here of people that have assets that exceed about 50 million naira. So basically, what we're just trying to say here is while every reasonable adult should start thinking about planning a will, specifically if you're married, if you're a parent, or you have a high net worth, then it's very vital and very important for you to start thinking about planning for your will. So the next question is why one should plan for a will. Of course, there are quite a number of reasons. We have already given great examples of how prominent families have been thrown into disarray when disease dies intestate. That's when a disease dies without a will. So, and then what happens is when a person dies intestate, due to the polygamous nature of our legal system, the estate of the deceased is now left for the interpretation of the courts. And this is something that you would not naturally want to leave to chance. So basically, this just highlights the importance of a will. You know, it's always important for one to plan for the afterlife because of for various reasons. We're talking about financial security for your loved ones, appointing desired guardians, avoiding inheritance disputes, avoiding intestacy. So these are issues that one would naturally want to avoid. We also further discussed about when one should start planning for a will. So basically, as earlier stated, upon the ideal planning age of 18 years, there are a number of factors that one should consider. This is your income level, how many dependents that one caters for, debts owed. These are all important factors that one would have to put into consideration when trying to draw up a will. And also another very, very important issue that one should also put into consideration is the fact that you also have to think about the likelihood or the adverse effects that would happen in the event that you fail to plan for your estate. So those are the things that one needs to bear in mind. Also, we also have to talk about, we also illustrated on who to talk to when planning. As earlier stated, we had also suggested that, of course, the impact of a legal practitioner is very, very vital. But besides legal practitioners, there are also other professionals that one would necessarily have to talk to when trying to plan a will. These are asset managers, estate planners. Mr. Ibidolapo had also talked about digital assets. So this now means that there are people called portfolio managers, as well as financial analysts. These are all professionals that become very, very vital and that can render tremendous assistance when one is thinking about planning for the afterlife. So the second part of the report basically deals with estate planning. What we put in there is basically the whole concept of estate planning and why it's very, very important. Most of this has already been touched on, especially the concept of estate planning, but I'll just go through that briefly. So estate planning basically just connotes arranging for the orderly transfer of one's assets. It covers the scope of wills and codicils to trusts, as well as deed of gifts, as well as also special vehicles of transfers and also powers of attorney. So these are all various means through which that form the whole concept of estate planning, which have thoroughly been dealt with in the report. Now, this is very important, as we had said earlier, because the implications of not having a will can be far, far reaching. And those are things that we want to avoid. Now, we also talked about various myths that are not necessarily, that don't necessarily exist. They just reflect the thoughts of the average person. For example, most people have worries or concerns, which often scare them away from deciding to draft wills or plan or have a succession plan. For example, we highlighted and we put some of them. For example, here we have people talking about being too young to plan for an estate, not needing a lawyer to draft documents, thinking about the fact that maybe putting in a trust plan is very expensive and it's just for wealthy people, and that even the mere fact that one has a will deals away with the issue of probate, means that there are no problems cannot necessarily emerge. But this is not necessarily so, because sometimes you find that people come to contest wills. So these are all myths. There are much more detailed in the report, and there are quite a number of them. These are all myths that do not necessarily exist and that one should be very, very wary of. So we also put up a step-by-step planning guide, more or less like a checklist that one has to try to assess before one goes ahead with the process of drafting a will. For example, we've highlighted them here in chronological order. The first one is having an inventory of one's stuff, both tangible and intangible assets. So the first step is actually assessing or having an inventory of both your tangible and assets, such as home, land, real estate, stocks, bonds, mutual funds. These are things that one just has to have an inventory of. Next, you also have to account for your family's needs. You have to think about the future and how to protect the assets for you and your loved ones after you're gone. There are also things like life insurance. If you have young kids, you might want to name a guardian for them or a backup guardian just in case when you're writing a will. Also, you also have to establish directives. This has to be very clear. This has to be very deliberate. It has to be intentional. So this connotes having a complete estate plan that includes your directives. For example, you might want to have a medical care. You might want to have wishes that spell out how your medical care will be executed. Next, you also want to review the beneficiaries under your will. So your will and other documents may spell out your wishes, but it might not be all-inclusive. So your beneficiaries have to be clearly spelled out. Another thing to take into consideration, which is why we also highlighted the importance of the lawyer, is that you must note your estate's laws. So because laws can vary according to jurisdiction or location. So a lawyer is always in the best position to advise on the appropriate law or applicable law when drafting a will. And then you can also weigh the value of professional help. So what this means is, we had spoken earlier about various professionals. This just means you just have to assess the value that you get from professionals as opposed to handling things yourself or just having a random attorney to assist you in drafting the will. So they are also what they call estate tax professionals. They are succession attorneys that are also specialized in drafting of wills. And then lastly, what often happens, or what is often the case, is when people draft wills, sometimes things change, and so should your estate plans. You might want to revisit your estate plans when circumstances change. Maybe when you lose an asset, or when you add an asset, or when there's a marriage or divorce, the death of a child, or the loss of a loved one. So these are part of the things that one needs to put into consideration as a checklist when trying to plan for your estate. So the third part under the report deals with insights from legal practitioners. So over the course of drafting wills and also in personal experience, we've come across quite a number of mistakes that can be very, very costly. The first one is thinking or believing that one can draft a will by oneself without guardians or inputs of a legal practitioner. We've highlighted how this can be very fatal and this can be very costly. And this is not something that we advise at all. Secondly, it relates to appointing executors. It is always advisable to have executors that are younger than a testator, because executors they need to outlive the testator. Mrs. Yvonne had spoken about having executors that maybe in their 90s or or elderly. It's almost impracticable to have old executors that would outlive a testator. So this is not advisable at all. Thirdly is the improper execution and attestation of a will. The law is that beneficiaries of a will are not supposed to attest to the same will. And what this means is that the spouses of attesting witness can equally not benefit under the will. So that's something of note as well. And also, it is also improper to insert burial of furniture or funeral wishes in a will. What this means is that wills are usually read after funeral rites are concluded. So it is also advisable that funeral rites should be possibly be written in a separate document. In the country, in Nigeria as it is now, most people also shy away from administering wills or writing wills because of the challenges that are faced in administering wills. For example, we just had the recent incident at the High Court where the whole probate was burnt. And you can imagine the devastating consequences that would have caused. And so it's part of the challenges. We still do things the archaic and the old way. So most people prefer, because of reasons such as this, most people do not lodge their wills at probate registry. They just keep it by themselves, possibly without informing testators. And it's one of the challenges that we have. Probate administration in Nigeria is obsolete. Storing physical documents now is very, very risky. We do not have a digital system or a digital archive or a digital platform to administer wills. We still do things the old way. And then also, one thing that people are also particular about is the cost of administering wills. We do not have a defined system. We don't have a transparent system. Sometimes you go to the probates and they're asking for facilitation fees, mobilization fees, and all of those things. These are part of the challenges that we have that can be very, very discouraging. So, but regardless of that, testators are always advised to lodge their wills at the registry just to avoid disputes, to avoid litigation. And part of the suggestions that we now have is that the traditional filing system should be replaced with a digital electronic filing system, just as it is in developed jurisdictions. Now, as a beneficiary, there are so many things that one also has to have or one needs to have in mind. What ranks highly in this list is that as a beneficiary, you want to monitor the process of probate administration. Beneficiaries have the right to invoke access to information and timelessly receive entitlements under the will, as opposed to just folding arms and just expecting things to just work normally as it should. So what this means is beneficiaries must be very, very vigilant, and this is always in their best interest. So the fourth part of the report deals with the ecosystem, the whole ecosystem that involves the administration of wills. So this involves the executors, this involves the beneficiaries, and this involves the testators. What we did under this part of the report was to focus on trustees, and we also spoke about the roles and then the duties of corporate trustees. Mr. Ibidolapo had spoken about this earlier, but I will just quickly go through them again. So corporate trustees are just companies that act as trustees under the trust. They are registered under the Nigerian laws. And right now, as it is, we do not really have a refined or a modern applicable statute that governs corporate trustees in Nigeria. We just have the Trustees Act, although there's a public trustee law of Lagos State, which now recognizes both public trustees and private trustees. What do corporate trustees do? What are the services that are offered by a corporate trustee? This varies. They offer asset collation. They even draft wills. They update wills. They republish wills, and they also serve as the roles of executors and trustees over an estate. Corporate trustees also have the power to invest either part or in full of the estate of the testator, except where this is expressly forbidden under the will. They have the power to insure assets under their management, and they also have the power to sell any security, real or personal, for any debt or for any property as they deem fit. So part of the challenges that are faced by trustees is the lack of public knowledge amongst the general population. People also, have low trust in trustees. There's also the fear of what happens when I give my assets to a trustees. And people also have, internal and external conflicts in managing trusts. And there are also, as we said earlier, regulatory constraints. But these setbacks or these challenges are not in any way outweighed by the advantages and the benefits that one derives from having a corporate trustee. So, as a corporate trustee, they also have duties. A corporate trustee is meant to be honest. They are also meant to be loyal. They are meant to be they're also meant to have very high integrity. They have duty to account, duty to manage and distribute the trust efficiently, duty to consider beneficiaries, duty to act gratuitously and not to deviate from the terms of the trust. Besides the duties of a trustee, there's also the role of trustees. The roles have to do with the characters. That's the character traits that a trustee must exhibit. We've highlighted some of them here. They must ensure that they properly gather the estate of the testator at least 12 months within the testator's death. They're always expected to act in good faith. They're always also expected to cover the expenses of the testator of the estate, and especially things like funeral expenses. They're also supposed to issue assents to beneficiaries. They're also required to give accounts and inventories of the estates and giving accounts to the beneficiaries whenever they are requested. We also have two types of private trustees, generally two types of trustees, the private trustees and the public trustees. Public trustees are usually a creation of statutes, and where a trustee is not created publicly by statute, then it is deemed to be a private trustee. And the other part of this section also deals with the role of beneficiaries. So what we talked about here is what is expected, the roles that are expected to be carried out by a beneficiary upon the death of a testator. So what happens is once a person dies, the beneficiary is meant to identify if the deceased dies without a will and ensure that an executor is appointed, who is appointed under the will, performs his duty and assumes that same position as well. So what happens is, while it may seem simple, while the role of beneficiaries may seem simple, sometimes we have wills that are contested. Sometimes we have disputes as to who is entitled to beneficiaries under a grant. So which is why it's very, very vital that beneficiaries must carry out these roles. Also, where a person dies intestate, which means where a person dies without a will, there are declarations with respect to how the estates can be carried out. And so we also talked about this as well. What happens is the estate is deemed to have invested in the chief judge, and the personal representatives of the family of the deceased who died intestate will now have to approach the probate registry with an application for the grant of letters of administration to be made to a probate registrar. So what happens is, whether it's a surviving spouse of the deceased, that is where there's no will, whether it's a child of the deceased or an offspring, these are personal representatives of the family who have to now make an application to the probate. This application is supposed to be accompanied by, a death certificate, passport photographs, and affidavits, along with other documents that are listed here. Once this has been done, the court would now grant letters of administration to the personal representatives. So where deceased dies with a will, he is also described as a testator and has the legal authority to such will by probate registry. This is known as the grant of probate. So what happens is an application has to formally be made. The application for probate in this instance will be done through a letter that contains the details of the testator, the date and place of death, evidence that the testator lived within the jurisdiction of the court before the death, the testator, and evidence that the testator has a will, and that the applicants are named as executors in the will. There are also other documents that have to accompany this. This is a copy of the will, the death certificate of the testator, and a proof of ID of the testator himself, an affidavit stating the place of domicile of the testator shortly before the death, and also at the time of his death, and a declaration of the personal properties of the testator. So basically, after that, we now have the conclusion. So what we just did is just to summarize the whole report. We focused on, I'll just go back to the basic just to recap on everything that we focused on. The first part of the report dealt with who, why, and how to plan. The second part dealt with estate planning generally. Then the third part also dealt with insights from a legal practitioner and the mistakes, that often come with that. And the fourth part also dealt with the general ecosystem of estate management. And then the concluding part of the work just summarized everything that we've said so far. So that's just what we had there. So thank you. Thank you.
Thank you very, very much, Mr. Kolawole OLANIPEKUN, for that very interesting summary. Just shows the depth of that report. which you partnered with Proshare and Personal Finance, Wills and Trust, Planning for the Afterlife. It's really interesting, the things you highlighted, and it's very important that you improve public knowledge, address the issues of fears, and the rules of corporate trustees have been clearly spelled out. We need to ensure that there's digitalization again, that proves to be repeating itself from when Ibidolapo and of course Yvonne gave her presentation. It's very clear that we need to digitalize the process and improve public administration. So thank you very much for the presentation. I really appreciate that decisive report from you, analysis. OLANIPEKUN, Kolawole OLANIPEKUN is the Senior Assistant and Head Business Development Stack with Girl Solicitors. We'll now go on the break, then we'll return, continue the conversation.
You've reached the stars, now let's see you conquer galaxies. You've gone for gold, let's show you 2 more treasure chests.
Your story doesn't have to end with you. As a matter of fact, it can continue into the next generation.
The only way to move is up, the way to go.
And the generation after that.
Don't stop.
After all, you've worked hard to get to where you are. Why should your wealth end with you? Let your story continue.
Meristem, let's grow wealth for you. For you.
Ever wondered how you can preserve your legacy? Let's talk about how to set up a simple wills and estate planning. The United Capital Simple Wills and Estate Planning products allow you to state how your assets will be owned, managed, and preserved during and after your lifetime. United Capital Simple Wills and Estate Planning covers living trust, family trusts, wills and executorship, asset disposition, custodial services, and procurement of letters of administration. Here are some of the reasons why our Simple Wills and Estate Planning products is great for you. You can plan your estate using a will or a living trust designed by you. You also take control over your assets and decide the terms and enjoy strict confidentiality, estate protection, and experience estate management. Don't wait another day. Simply download the Invest Now app and complete your KYC to get started.
The Proshare mobile app, your non-stop access to financial and economic information. With the Proshare app, you can customize your preferred news and videos. You can also get access to latest financial and economic news. Watch videos related to business, economy, financial markets, and lots more. The Proshare app gives you in-depth market stats from the NSE, FMDQ, and NASD. That's not all. You also get real-time alerts. The Proshare mobile app. Information at your pace and in your space. The Proshare mobile app. Your non-stop access to financial and economic.
Welcome back, and we've come to the very interesting part of our conversation, which is the Q&A. And I believe that I must appreciate everyone that sent. We have about 13 questions that we're going to work with time to ensure that we address them. So my appeal to our co-panelists is just to give a very precise answer. We can make it within 30 seconds answer precise. That will be well appreciated. At the point we may not be able to address all of them, then we would find a way to respond to our co-panelists. So the first question is from Uche Anuniru. She's asking, is it possible for a lawyer to prepare a will or trust to tamper with it? How does one guard against this? So I direct this question to Yvonne EZEKIEL.
Hi. This is a noble profession, as I like to say, and I want to claim that it is. I think in every element or every sector, you might find some unscrupulous people. So while we would suggest and always advocate that lawyers are consulted in the preparation of wills and trusts, you may find one or two people who could do something untowards, but largely, by and large, lawyers are advised to be used in the preparation of wills. Lawyers are advised to be consulted when you want to put a trust together, because they would advise you on the legal pitfalls that you may encounter if you do not use them, like I mentioned before. So I won't focus so much on those who could do certain things, but I think it's really advisable that the guys in the legal profession who I consider noble are used to do this, to prepare wills and prepare trusts. And the fact that you would lodge them with the probate registry, for example, is highly unlikely that the wills can be tampered with. And because the trust also it's something that is living while you're still alive. So it means you should be able to pick out anything that could happen to the trust without your knowledge. So yeah, but having said that, there might be one or two individuals who could do something unscrupulous, but a large percentage would make sure that they're doing the right things.
Thank you very much, Yvonne. The second question is from Ademola Okunaya. He's thanking the organizers of this webinar for putting up a very interesting conversation around the wills and trust. His question is, in the case of a living trust, even after the transfer of your assets to the trustee, is it possible for the settlor to still have a say or active participation in managing those assets? Is there also a way to prevent the trustees from mismanaging the assets in the trust? I'm directing this question to Ibidolapo.
So yes, when your assets are transferred, depending on the type of trust you have, whether discretionary or non-discretionary, that is what will determine if you would have a say in the management of the trust. So if it's a discretionary trust, affairs are left to the discretion of the trustee. If it's non-discretionary, the trustee may then have to speak with you to know the direction of the management of the trust. And then about mismanagement, like I mentioned, trustees are held to very high standards. It's a relationship of fiduciary, so they are meant to do everything in their power to ensure that they manage your asset properly. Also, I mentioned in the course of my presentation that you can appoint protectors over your trust, who, even when you are no more, they monitor the trustee to ensure everything is done. And lastly, don't also forget that most corporate trustees are licensed under with the Securities and Exchange Commission. And so you can always report to the SEC, and they are wary of SEC sanction. Thank you.
Thank you very much, Ibidolapo. I'll still stay with you for the next question from Uche Amiru. This is her second question. She's asking in layman definition. So I know that Ibidolapo, you're quite young and dynamic. So can you give us a layman definition quickly, in a few seconds, of settlor, executor, and probate?
So a settlor is simply anyone who sets up a trust. That's it. It could be you and I, anyone who sets up a trust for their loved one or for any beneficiary is a settlor. Then for executor is the person who is like the driver of your estate when you are no more. So when you are no more, you are meant to appoint someone who would take charge of the administration of your estate. This is the person who would apply for probate. Once the person gets probate, who would gather your asset and distribute your asset. That is who the executor is. Then probate. Probate is simply the process that the executor goes through to get a document. The document itself is what is called probate, to get that document that ensures they do all you expect them to do under the will. Thank you.
The next question is from Ajibola Awolowo, and this goes to Kolawole. If a young person sets up a trust and transfers his or her assets to the trustee for any further asset this person acquires, will it be acquired in his or her name or still in the name of the trustee? How is this done objectively?
Like he had asked, if you're adding assets to a trust, of course, that's very possible. So what happens is the assets firstly have to be acquired by you, so they're back in your possession. So it's simply what you have to do is just make what is called probably a schedule, because they have a schedule or inventory of assets that are always added to a trust. So what happens is once you acquire that in your name, you would now have to assign that or give that to your trust again, or execute that in favor of or transfer the title of such assets to your trust again. So like he said, for a young person, that's just the process that he just needs to be followed. Once the assets are acquired, then you now add it to your trust afterwards. Because like I said earlier, these things change. One acquires properties over a period of time. So it's not a very, very difficult process at all. Yeah.
Okay, thank you very much for that response. Now, next question is from Elizabeth, and this is for you, Yvonne. So Yvonne, you can make your inputs to the earlier question and tie it to the response to this question. She's asking, with a will in place, some family members may still want to act as intruders and dispossess the rightful beneficiaries of the estate. How can beneficiaries take care of such intruders?
So, because in the will, that's why we said, first of all, the will has to be in writing, and you also need to state who your beneficiaries are. And if the will is lodged at the probate registry and probate is granted to the executor, which essentially legal date to execute the will, there's no way he would be distributing assets to people who were not part of the will, who are not beneficiaries to the will. So essentially, the law supports or protects the beneficiaries of a will. So if anybody who is not a beneficiary tries to come in and make a claim on the will, it's highly unlikely that the law will support that. The only instance that they might try to claim is if they're trying to invalidate the will because some features were not followed properly, either because you had the wrong executors or it wasn't properly attested to, or one of the beneficiaries signed the will. Then you've left the will open to be contested and being invalidated. But if the will is done properly, it's highly unlikely that anybody else who has not been named a beneficiary in the will be entertained. Whatever complaints they have will be entertained.
Thank you very much, Yvonne. Next question is from Abdulmajid Odemi, and this question goes to Lapo. How best can one plan around an asset or property inherited that is actually not in your name, but intend to transfer such asset or property to your child or children?
All right, thank you. So if you inherit any asset, so I would assume, say, under a will or under any form of, even if it's intestate, for example, there is what is called assent that the executors are meant to prepare at the point where the properties are to be transferred to you. So, and that assent carries your name. So probably the person is talking about customary inheritance where there is no document and all of that. So if it's in that case, you may, so once the asset is already yours now, you may then need to take a step to perfect such a title if it's not already perfected, register it such that it's now in your name, and so you can then transfer to your beneficiary. Because what you exactly want is for everybody to know that this asset is now in your name. But if it is an asset that you inherit under your will, ordinarily an assent will be granted to you, which is like a vehicle of transferring that asset to you, which already has your name and all of that. Of its customary inheritance where there are no documents and all of that, you can take a step to register such title with the registry if it's land, if it's landed property that we are talking about. Yeah, so that's one way to go about it.
Thank you very, very much, Dolapo. Now to Kolawole, Ajibola Awolo is asking, can an individual decide to have some assets outside of his or her trust, which has been set up with a trustee?
Yeah, the simple answer to that question is yes, because the assets are yours. You're the one that decides which assets you want to give to your trust. So of course, yes, you can have some assets outside your trust, which has been set up with your trustee. So it's left at your discretion to decide what you do not want to give.
Thank you very much, Kolawole. Uche and Nuru has been really participating. Ask another question again, and this goes to Yvonne. Can one lodge a will in a probate registry of another state different from the state where one lives?
I mean, you could, but that means you want to be subject to the laws of that state. There is something called, my place of origin plus my place of residence. And I think the Supreme Court, there's a case where the Supreme Court has decided you can actually choose where you want to become your place of residence against your place of origin. So if you decide that you want to go lodge your will in another state, then you'll be prepared to obviously subject yourself to the laws of that state. Yes.
I'll still stay with you, Yvonne. It's a question from Festus.
Yeah.
In writing a will, could one state that the executor make a search using one's BVN as more financial assets could emerge following depositing such wills in the probate registry? Did you get that question?
Say that again, please. No, say it again.
The question is from Festus Ogumoko. He's asking, in writing a will, could one state that the executor make a search using one's BVN as more financial assets could emerge following depositing such wills in probate registry?
I mean, what you write in your will is what you expect to be carried out, essentially. So it is not the wishes of the executor, but the wishes of the testator. That is the person who's writing the will. And what he is seeking is that his wishes are carried out. Now, unless there is an issue with the estates where there are some liabilities and debts that need to be settled, and it requires something else outside of that, but simply for the purpose of settling the debts, then that has to be done. Whatever needs to be done needs to be done. But by and large, it's the wishes of the testator that is written there that has to be, you must abide by and must be executed. And that's why you're the executor, to execute those wishes. Your role is not to go outside of that, but to execute what he has said. But bear in mind, like I said, sometimes, the key thing is if you have liabilities, then those have to be settled first before your wishes are carried out.
Thank you very much. Adewale has a question, and this is for Kolawole. Is it possible to revoke a trust? What could be a valid reason for wanting to revoke a trust?
Yes, of course, it's very, very possible, although we rarely come across occasions where trusts are revoked. So the most important reason why you might want to revoke a trust is maybe where there has been a fundamental change that it will possibly most likely be easier, to revoke it and possibly execute a new one, as opposed to maybe just making modifications. This could be as a result of fundamental life changes, maybe a divorce, loss of a child, or a beneficiary, maybe someone's net worth has been significantly impacted. These are all reasons why a trust might want to be revoked. And then most times, if such change is so extensive or so significant, that it would be a lot easier to execute a new one, as opposed to making maybe alterations or modifications. Then those would be very valid reasons for wanting to revoke a trust.
Kolawole, I want to stay with you. Yeah. Sherif Azan actually wants you to answer this one. What are some of the best practices in the archiving of wills and probate registries world over? And how can Nigeria key into this trend given its importance?
Okay, yes, I'd made mention of this earlier as well. The world is going digital now, and with the advancement and the trend of technological practices the world over, the best practices in archiving wills will now be digital security or digital platforms to archive these wills of testators. So what happens, or what is obtainable in some states now in developed countries like the US and in the UK, is that they have secured and certified platforms where all these probates, all these wills are stored digitally and electronically. Well, thinking about Nigeria, we're still a bit far off because we tend to catch on a bit slowly to all these practices. But over the course of time, with the issue of raising awareness and establishing, better practices now. I think with time we can key into this trend. So basically, that's just it.
Thank you very much, Kolawole. Next question is for Dolapo. Dolapo, Emmanuel Ohiwi ask how this is well, this somewhat. It says, how do I secure a UK property for the afterlife being purchased by a mortgage agreement and part financed by Nigerian commercial bank?
Hello, I can't hear that question. I think it's rushed. Can you just take it slowly?
All right, thank you very much. Emmanuel Ohiwi is asking, how do I secure a UK property for the afterlife being purchased by a mortgage agreement and part financed by Nigerian commercial bank?
All right. Okay, so if you have a UK property and let's take it broadly, and there is a mortgage on still on that property, so it means that first and foremost there's a debt to be discharged, and the debt has to be discharged from your estate because your just debts and liabilities should be discharged from your estate. Then secondly, yes, the asset is yours, and you can always make an estate plan around it. So for example, if you have an asset out of the country, you can write a will. And if it's a country that we have a relationship or a convention with, there's something called probate resealing, whereby if the asset is outside of that country, based on whatever relationship we have with them, they can recognize whatever probate you've gotten in Nigeria. It is seamless if it's in if there are different states in Nigeria because of the Probate Resealing Act, but there's also a convention whereby you can use that probate that you've gotten in a country and then take it to a relationship country to get probate. So yes, it's something that you can put in your estate plan, and depending on the laws of the jurisdiction where the asset is located, you then know what step you need to take. Would the resealing take place, or there are processes that you need to go through before such a property can be taken up by your beneficiaries in whatever country that it is. So two issues here: whatever mortgage you have on it, which is a debt on that property, will still be repaid by your beneficiary. And secondly, yes, you can have it in your estate plan, and then you need to then follow what the rules are of that country to determine how your beneficiaries will get the asset out. Yeah, thank you.
Thank you very, very much, Dolapo. We have two more questions, and every other person that has sent questions in would respond to you via this platform, and of course, reach out to you because of time. Onyebuchi Uchela, this question is going to Kolawole. Just in a few seconds, what's the ideal qualification of a private trustee?
Yeah, so a private trustee can either be an individual or a corporate establishment. In the case where it's an individual, the person must be of a sound mind, and must have attained a legal age of an adult. For a private trustee, it must be a legally registered entity that is capable of executing, the functions and acting in that capacity as a trustee. So basically, those are just the basic qualifications or requirements of a private trustee.
Thank you very much, Kolawole. And this is the last question going to Yvonne. In a letter of administration, can the administrators also be beneficiary of the estate? This question is from Soji Oyebisi.
Yes, they can be, especially if they are the next of kin, and you can actually prove that you're next of kin. So typically, you will find that a wife of a deceased could be the person who would have gone to apply for letter of administration because the husband hasn't left a will. So yes, so she could be with an additional person, which could be a child or another relative, and yes. So yes, if it's the wife, for example, she could be a beneficiary to the will, so to the estate. So yes, she can be an administrator.
Thank you very, very much. Like we said, other questions that came in, we would respond to them. We'll talk to our companies and respond to them because of time. So we can really, it has been a very interesting conversation. I want to thank all our participants that have still stayed on to this time. I want to thank our companies, but it's been a very enlightening, educating, and empowering session on the value of estate planning, wills, and trust. I would now like to get your closing thoughts, takeaways from each of the speakers. it's very clear that this cuts across religion, tribe, race, and even ideological orientation. We must plan for the afterlife and strategize. I'll first begin with Yvonne, EZEKIEL, managing partner of Mr. Agbakoba Legal Firm. Your closing thoughts.
So very quickly, so very quickly, I'll just say thank you all very much. Thank you for the opportunity to speak. My closing thoughts would be to just say to everyone that wills and trusts are excellent estate planning tools, and I would employ everyone. No one is too young to put a will together. Choose what works for you, but also make sure that you always use the services of a lawyer to get the advice.
Okay, I think I could get clearly that it's important that we engage the service of a lawyer in terms of wills and trust and administration. Thank you very much, Yvonne, EZEKIEL. Next is Kolawole OLANIPEKUN, Senior Associate Head Business Development, Stack Legal Solicitors. Your closing thoughts.
All right. I'd just like to, I'm very grateful for the opportunity to have been here and to also have worked with Proshare on this report. It's also been a privilege and an honor to have spoken alongside our esteemed panelists. The issue of wills and trust is something that people tend to shy away from. I don't know whether it's consciously or subconsciously, but it's very, very vital because it's still part of life. And I feel like it's something that, should be talked about and spoken about a lot more often. And I think it's high time we raise awareness on all of this, because it's not just in one's best interest, but also in the interest of your loved ones, your family, and your friends as well. So it's been a very, very insightful program, and I'm grateful for the opportunity as well. Thank you.
Thank you very much, Kolawole OLANIPEKUN. And next is Ibidolapo, OLUFADE, the Trust and Legal Officer for Meristem. Your closing thoughts.
Okay, thank you, Ottoabasi. Thank you, Proshare. And a very big thank you to the esteemed members of the panel. It's been awesome. And I'm very sure that our esteemed participants have also left with one or two things. So I'll just end by saying, it's the word of D.K. Rowling. It said, to the well-organized mind, death is the next great adventure. So when you are no more, it's just an adventure for you, because you are rest assured that your loved ones are at peace here. So yes, organize your affairs. Thank you.
Thank you very much, Ibidolapo, and very nice quote you put it there. Well organized. Planning is very important for our life. Thank you very much once again. And I would now like to yield the floor to the Managing Director and Chief Executive of Proshare, Mrs. Grace Nigeria, do you want to give giveaways, and of course, a vote of thanks.
Indeed, it has been a very insightful session today. And on behalf of the board and management of Proshare, I want to say a very big thank you to all our sponsors, supporters, and speakers for sharing insights with us today on the nitty-gritty of estate planning and wills and trusts. Like I said earlier, it's been insightful and thought-provoking session. And I'm sure that participants here today and those that will be watching the replay after would be moved to take action to ensure the future of their dependents is secure during and after their life. As promised, would be doing the random selection for the giveaway now. So I'm just going to share my screen so I can share with us the number of people that filled the form. And I would like our speakers to do us the honors of choosing the people as well. Okay, so we have it here. About 23 people filled the form. So I'm just going to open the Excel sheet now to see everyone. Okay, so we have 23 people using a selection process, using Excel formulas. I'm going to do a random selection between 1 to 23, and we're going to match the numbers. So number 7. So we're going to match this random number with the names of the people that are here. Okay, so we have the first person that is going to receive this giveaway, and I must say she has really been participating. She sent in almost about 3 questions. That's Uche Anuru. Congratulations, Uche. You are the first winner for our giveaway today. So I would like Mrs. Yvonne EZEKIEL, please help us count down from 1 to 3 so we can pick the second winner.
3,
1,
2,
2,
1.
Okay. 3. Okay. There we have it. We have Dixon Ogala. Dixon Ogala is the next. We have Uche first, and now Dixon. Okay. The third person, please, Mr. Ibidolapo, kindly help us count down again.
I'll start from 3.
Okay, 3.
Okay, 3, 2, 1.
Okay, there we have it. Olumide Oshunyemi, congratulations. Okay, Mr. Kola, kindly help us count down.
3, 2,
yes.
1.
1. Okay, the fourth person, Ademola Okunaya, congratulations. And Mr. Teslim,
Okay,
the last person.
Okay.
Yes, I can.
I'm counting from 3 to 1.
Okay.
3.
Yes, sir.
2.
Yes.
1.
1. Okay, Ishola Abdul Aziz, congratulations to each and every one of us. Thank you very much once again for participating. We would reach out to you after now with respect to how you would get a copy of the reports. Like we said earlier, it's worth about 5,000 naira, and we've actually put in quite a lot to develop this. And I'm very positive that you would benefit greatly from reading the report thoroughly. Okay, so thank you very much once again. Would really appreciate if you can take the feedback survey after the end of the session. Immediately you sign out, you would see the feedback survey. Would really like to have more of these sessions, and again would call on our sponsors and more sponsors out there hearing us to partner with us so we can actually continue to enlighten, educate, and empower our audience to actually do better with quality, credible, and reliable financial information that they need to manage their monies and also to multiply their monies, because I know every one of us desire that. Thank you very much once again for being a part of this session. We really appreciate the time taken. It's almost 3 hours and over 50 people have stayed glued to this. I really appreciate you. And to all our sponsors, to our legal experts, thank you very much. And do have a splendid afternoon. Thank you.
Thank you. Thank you.
Thank you.
Goodbye. Thank you.
Thank you very much.
Tune in to WebTV Daily to stay up to date and informed on the financial market, personal finance, and more. We have got you covered with all your favorite TV shows, economy and politics, market review, women's series, millennial talk, Islamic Finance Weekly, The Brief, exclusive interviews, events, and we keep you up to date on all the updates in the financial market with the market opening gong. Watch premium content. Watch WebTV. Same news, different perspective.